Here's the weird part of the statute. Section D says, if there's a disagreement with the committee decision. And I should back up and say, who is this committee? Well, the committee is typically comprised of nurses and doctors, risk managers, case managers from the hospital. In other words, you have a doctor and a risk manager, typically, who's presenting the case against care, presenting to the colleagues of the doctor and the risk manager. So it seems a little bit of an inherent conflict of interest, but that's how it works. If the committee, what I call rubber stamps, the doctor or the risk manager's recommendation, then what happens? Well, this is where it gets interesting, because Texas is one of only 2 states in America that has a statute anything like this. The other state is Virginia. Under Texas law, the family, the patient, has 10 days to get a transfer. At the conclusion of 10 days under the statute, food, water, all types of nutrition, and all types of curative care end after 10 days. You have 10 days to do this. The statute goes on to say then that the hospital and the physician have to make the undefined term of reasonable efforts to assist in obtaining a transfer. And it all happens in 10 days. So I want you to think about, in terms of your process, your practice, your clientele. You get a client that calls you Friday afternoon and has a story. You're getting ready to go home, spend time with your family, and they say, look, a hospital just called me, someone just called, I have my uncle or my father, my son, whomever, my mother in the hospital. Monday morning, this tribunal is going to set in judgment, and they're going to come in and have all the medical experts, have everything together, 48 hours notice. How do you stop that? There's only one narrow way that you can do this. And the statute does say in 166.046G, the court shall grant additional time if there is, the undefined term again here is, if there's a reasonable explanation, or rather reasonable expectation that additional time would allow you or allow the family to find a facility that would accept the patient. Unfortunately, there are no procedures that are defined in the statute of how you actually get to the court. You have to go to a county court or a district court, and I'll tell you in practice the way it's typically done is you go and file a TRO. Usually they're done ex parte, and usually they're done very early Monday morning, because the ethics committee proceeding is usually at 9 o'clock. So they're done on an expedited way. Now the courts, honestly, I haven't seen the judges of either party in Houston that really, they don't know anything about the statute, and they don't really like getting involved, because it seems a little strange if you think about having a judge thrust into the treatment room and trying to make a decision over whether, you have these interesting evidentiary hearings over whether or not any of this is going to make a difference. You know, the doctors are coming in saying, or the hospital witnesses are saying, look, this is futile, this is a terminal case. You have the family coming in presenting evidence otherwise. This can happen all very, very quickly. So you're talking about, you get the call Friday afternoon, you might be in front of the judge Monday for the TRO, but a lot of times the judges want to expedite the temporary injunction hearing and have it that week. So this is something that's a very brutal process. The only way, though, that you can challenge this is this one section, 166.046G, this injunctive relief you can go after. Now, it gets better. This statute ties into 166.045D. This is a really unique, a very unique provision here, because it says that anyone who acts under the procedures set forth in Chapter 166 enjoys complete immunity from criminal, civil, and administrative review. So I came upon something called the Coase theorem. Any of you hear that in law school? Any of Coase's writings, the economic effects of law, how you want law that puts the economic or the decision-making influence in the right position, so people will do the right things. That's hopefully what the law does. And I talked about this, this specific statute and how when you put immunity, and this is immunity that's better than judges enjoy. It's immunity that's better than legislators enjoy. It's a better setup than President Obama enjoys, as Richard Nixon would attest to. None of this is as good as this immunity. But if you think about, how do you think this decision-making, and not again ascribing motives to any particular doctor, any particular hospital, but how do you think this applies in decision-making, or might influence economic decision-making of facilities when you tie it into the liability caps of tort reform? Any thoughts on that? So, you don't do med-mal. Tort reform is, I'm very familiar with this, is your non-economic damages are capped at $250,000. Your economic damages have no limit. So what happens here? Let's say that you have a case of medical malpractice, and it's a young person, say a teenager. This is a real case. You have a 16-year-old who has a promising future, has a brain injury. There is arguably medical malpractice. What is the liability of the healthcare facilities if the person dies versus if the person lives? How does that work? Anyone? Yeah?
Well, yeah, they're a lot better off if he's dead. If he lives, the economics could go on for who knows how long. If he's gone, I mean, it's almost set up as a system that it's cheaper to kill him than it is to hurt him.
No, that's exactly it. And one of the things that's really shocking, particularly in the young cases, I mean, we all know that eventually, if we live long enough, that our day will come. But if you think about a young person, you really, sometimes that happens, but you don't think, you know, as a father of four, I don't really hope that I'll be facing a situation where one of my kids will predecease me. It could happen. But one of the typical calls that I get when it's someone and it's a pediatric case is the hospital is saying, or the doctor is saying that I'm being selfish 3 days after my son or daughter went into a coma. The hospital is saying that we should go ahead and harvest our daughter's organs now. And by the way, the organ donation unit is downstairs. This is the type of thing that happens, and there's a lot of pressure into that. Any thoughts about this? How many of you has anyone experienced or had a client call you or talk to you about this system? Yes, sir.
Yeah, I've had someone call me before, the day before the administrative hearing or the ethics committee, and we've received this notice. We have a hearing tomorrow. What do? We don't have any, and the same thing, they didn't get any notice of what was going to go on in the room, and frankly, they're so scared at that point, they have no idea what to do.
Well, and the thing, Robert, that's surprising to me, where I think it's a system that's rather inhumane, in my opinion, is that if you think about whether you have an elderly loved one, whether you're in the hospital bed, or whether you have someone younger, whoever it is, they're loved. And if you're facing a potentially terminal situation, or at least a very serious situation, do you really want to start reading a legal notice over the weekend and try to figure out, with no knowledge, probably no medical or healthcare experience, no legal knowledge of what this procedure is, and really get thrust into this proceeding when you should be caring about your loved one?